appropriate. The first item on our agenda is a continued hearing for 35 Mountain Road. And the second item on our agenda is a hearing for Richardson Road. We're gonna take these items together. A motion?
Make a motion to combine 35 Mountain Road and Richardson Road.
Second.
Motion is made and seconded. We're gonna do a roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Joe, online? He's right in the middle there, but...
Maybe he's muted.
Give me a second. Joe, can you hear us? All right, well,
Technology is great stuff.
I can't get Joe. I vote aye. I'll say
Wait until it doesn't work.
4-0-1, an abstention, I guess, since we can't get Joe. He is online. All right. Oh, there you go. All right. Thank you. 5-0. Okay, the applicant is here. If you could give us an update where we stand since the last time we met, which was a while ago.
Yes, it was. Thank you, Mr. Chairman. Thomas Murphy here for the applicants. One is Gary Litchfield to my right and Jack Hussey to his right. As the board mentioned, these two applications kind of go hand in hand around the pending comprehensive permit. And it has been a while since we've been here. When we were here last, some issues arose about, questions about the access to get to the proposed property from Richardson Road, and there was some questions raised about whether sufficient access was available. Since that time, we've done research, we've talked to people, we've actually talked to a couple of different attorneys. Attorney Mark Bobrowski sent a memo, which I forwarded to the board a week or two ago. There are two issues in my mind in front of the board here this evening. The first one is whether or not the board is going to be involved in deciding on the access issue. When this was first raised back in the summer, Town Council, I think correctly noted in one of her memos that it's very rare for a permitting board to get involved in that type of a decision. That's typically left to a court. However, there was a case back in 2004 that said if something goes to the heart of the issue, then the board can get involved. In my opinion, one of the problems with that is who knows what the heart of the issue means. I don't. It's a matter of discretion. Different people have different ideas. Ultimately, it would be up to a judge, because whatever you decide certainly is not the final word on the access. One party or the other could appeal that, and a judge will ultimately hear it. So, to me, the threshold argument or the threshold decision for this board to make is whether or not what we're talking about goes to the heart of the issue here. We have a comprehensive permit application that Town of Burlington, through its Board of Selectmen and its Housing Partnership, has formed the opinion that this would provide meet a housing need and provide a benefit to the Town of Burlington. In Chapter 48 gives this board the authority to act as the permitting board in that type of a situation, to look at things like drainage and traffic and water runoff and size of the project and myriad of other things that go into permitting a large real estate development project. Nowhere does it say become land court judges and decide on access. So I would submit, and I said it before, and I would just reiterate for the record, I feel that this board should focus its efforts on the comprehensive permit application that's before it, in the knowledge that if you were to decide access one way or the other, in all likelihood somebody's going to appeal it, it's going to go to court anyway. So if it's going to happen, let the judges decide that, and you guys focus on what the statute provides you should be focusing on. I feel there's plenty of gray area in this particular case. You know, it's pointed out that one of the easement has language to contiguous property, but then it also says hereafter required property. What applies, what doesn't apply, what carries the day, what doesn't carry the day. There's a lot that goes into these types of legal decisions when you're talking about property ownership and property rights and easements and whatnot. And again, not to beat a dead horse, but I would submit that's up to a land court judge to make those decisions, because that judge will have the sufficient background and the knowledge and the ability to research it and whatnot to come to a correct decision. So, not to belabor the point, Mr. Chairman, but I would argue that this board should opt to stay out of it, because who knows whether this goes to the heart of the matter or not. That's an ambiguous term. Nobody knows what it means. But I would suggest that this board is better to spend its time on the comprehensive permit and those permitting issues, and leave the legal definitions and the legal findings to a legal body. Obviously, happy to answer any questions or address any of the concerns the board may have. Attorney Bobrowski had another case in another town this evening. He was going to try to make it online if he was able to get back in time. I don't see his name yet, so I'm not sure whether he's going to be with us or not, but he did submit a memo. He's a very experienced land use attorney, and his argument basically was just that. This is not one of those rare instances where the board should venture into determining ownership rights. Thank you, Mr. Chairman.
Thank you. Okay, I believe Brian Winter with Town Council is online. Brian, are you?
I think I heard my name, Brian Winter.
Yes.
Okay, I'm sorry, I don't have the video for the select board's meeting, so I see myself and a few participants, but not any of you, so I'll do the best I can.
Okay, are you getting the audio?
I'm getting the audio.
Okay. So I'd just like you to, touch base for the board, the memo that you sent out in response to the letter from Attorney Bobrowski.
And sure, let me summarize, because there's a lot of information, and in fact, our letter is just the latest in a series of letters going back to June or earlier of last year. And it concerns this issue, and I'm not going to go over the facts. I think you're all familiar with it, and very detailed record in terms of the deeds and the plans and history. Can everybody hear me all right?
Yes. Yep.
Okay, just wanted to make sure. I now see the board. I have the video up now. So fundamentally, what all those letters are trying to get to is this term, whether or not it's the heart of the matter before you, and I liken that to the applicant's ultimate task, which is to demonstrate the fundamental feasibility of their project. So while there's some back and forth on what that means and the case law surrounding it and what the board's role is with respect to that case law, I don't think anybody disputes that it's a decision the board has to make. The board is the ultimate arbiter of whether or not this access issue really goes to the heart of this application, and whether or not it touches upon the fundamental feasibility of this project. Now, what we're talking about is this access extension, easement extension, the last 95 feet there at Richardson Road, and the board is going to have to decide whether or not that access, or the lack thereof, touches upon the fundamental issues of this application. So to give you some other parameters about that, usually when you're looking at a 40B application, you're thinking about things like public safety, emergency access, vehicular access, all those other things. So you as a board have to decide whether or not all those concerns have a nexus with this access issue. So without going into the whole litany of the cases we all cite, and the deeds and the records, which I think you're familiar with, that's a decision that ultimately this board has to make. And if the board first decides that it is something that touches the heart of this case, then you have to make the second decision, which is, does this undermine the fundamental feasibility of this project? And if it does, then that's an obstacle. I don't want to put my thumb on the scale one way or the other. It's my job to give neutral and objective advice, so I'm just framing the question for the board. And I'm happy to answer any specific questions if you have them about that analysis. But that's my summary of our opinions to you.
Okay, thank you. Before we get to questions and comments from the board, I'm just going to read a letter into the record that came in from an abutter, actually dated November 1st, to the town clerk. Dear Ms. Warfield, the purpose of this letter is to state our objection with the Board of Appeals on the proposed condominium project by Windview Heights 2 LLC to be located on 35 Mountain Road, Burlington, Mass. My name is Alfonso Liu, L-I-U, I hope I said it right. I am a trustee of Liu Family Trust, which owns a single-family house on 11 Richardson Road, Burlington, Mass. The occupants of the house are my elderly parents. My father is in his early 90s. My mother is in her mid-80s. We feel that the noise from building construction, installation of additional utility lines along our property, and subsequent increase in vehicular traffic will severely impact the quality of life. They will be deprived of a quiet, peaceful lifestyle. Thank you for your consideration. Sincerely, Alfonso Liu. All right, I will put it to the board for comments or questions at this point, and see what everyone has to say. John, we'll start with you.
Just as soon listen some more. I'm not ready to make a comment on it yet.
Okay. Mark?
So my question for the applicant is, so are you asking us to put the cart before the horse? In other words, you seem to be saying, disregard this whole, goes to the heart of the matter on access. Go beyond that and start deciding issues related to the development of the property.
I wouldn't so much say I'm asking you to put a cart before a horse. What I'm suggesting is that whether or not there's access here is a contested issue. And I would submit it, that's a matter of it's a legal matter that, in my opinion, should be ultimately decided by a judge if it goes that far. So I just don't think that's an appropriate decision.
Well, how do you get there?
How do I get where?
How do you get to the courthouse? As you say, that's where we're going, no matter what, right?
There's two ways of getting there, frankly. If this board were to ultimately approve this comprehensive permit and one of the abutters opted to appeal it, then it goes before a court. If this board were to deny it, my client could appeal it, and then it could ultimately go to a court. So that's how these are, and, you know, this
So
board.
isn't there another option? Isn't there, I'd let town council comment on it, but you're seeking a declaration of your rights relative to the ownership of the title of the property, right? Isn't that what you're saying? The whole issue of access and title is something that ought to be decided by the court, right?
Correct.
And so there's another way to do it, right? You could seek a
The
declaratory
declaratory judgment is what you're getting at, I assume? I would suggest, frankly, we feel that we have access. So in our opinion, why should we go to court to prove something we think that we have? If somebody that doesn't agree with us and this board were to grant a permit, then somebody could certainly challenge that in court.
Don't we all, I don't know, I'm not going to speak for the other members, but there seems to be a lot of consensus around the issue that we're not experts.
Right.
The issue of deciding title
Correct.
and ownership.
Right.
Right? There are people with, and you know as well as I, those land court decisions are very complicated.
Mm-hmm.
They go on for a long time.
They do,
right?
yes.
So, and so, but why not just get to it? You see what I'm saying? In other words, why are we wasting a lot of time?
Until, I mean, you could say that to anybody that comes in here. Why don't you go to court and get the road paid for you?
But it seems more appropriate for this case, doesn't it?
If it's a dispute to go before the court, there has to be two parties in a dispute. So that typically, in these types of situations, happens when a decision comes one way and somebody doesn't agree with it, and they file an appeal. That's how it gets there.
Also.
I agree with you, but there's another way.
That may be. I would also reiterate that to get to where we are here, we did so with a lot of research and then moved forward and spent a great deal of money. The building is basically designed, not structurally, but it's designed. The site work has been all done. All of the drainage has been done. That has yet to be looked at by the third parties and so forth. But we're not walking in here with a brand-new project. This has been on...
You got a hurdle.
Excuse me?
You have a hurdle. You have a big hurdle, right?
A very big hurt, exactly. And we think that at this point, it's a matter of, does it go to the heart of the matter, as Tom says, whatever that really means, or should we move this thing forward? And the peril is on us. We're spending money every day. So the peril falls to us. And I think that the board
I'm only
should...
trying to offer some,
No, I hear what you're saying,
I'm not
Mark.
trying to
No,
undermine your application.
I don't think the suggestion is inappropriate. I mean, there is such a thing, as you know, to file a declaratory judgment. But we don't have two parties who are in agreement on the facts and the background. And typically, a declaratory judgment is, okay, we all know this is what happened, Judge. Tell us where to go. This is a dispute that's going to be...
But is that so? Couldn't there be a lot of issues that could be stipulated to? In other words, the documents are out there. Public record is there, whatever it is.
In a lot of, yeah, for a lot of the stuff, I
In
guess.
other words,
Yeah.
you could stipulate the facts and maybe move it forward fairly quickly. I still go back to, we're kind of putting the cart before the horse here. If there's this issue hanging out there that's gonna undermine the entire process, I mean, your client is saying it's gonna cost a lot of money to get there.
Costs a lot to get here.
It's cost a what?
To get here.
It's gonna cost a lot more according to your attorney, so.
Yeah.
No, you're right. You're right.
I'm talking about efficiency. I'm not talking about waste.
I think, yeah, you probably know that once you get into the land court, the word efficiency is not at the top of anybody's list. So,
But if
You
you
know.
stipulate to a lot of facts, you might be able to get to a quicker decision.
yeah, to see if initial question caught before the horse, I would just answer that by saying, I don't think that's the case. We're asking this board to decide the items that Chapter 48 directed to decide, and if and when it gets to a court, we'll let a judge make those decisions if and when it gets there. Who knows?
I
You guys,
respect your argument and your client's presentation, and I'm only trying to.
no, and I appreciate it. It's not a, like I said, it's not an invalid suggestion. I just point out that, and this board has seen it, you know, it's not uncommon to have different permitting things being in dispute. Neighbors show up, argue again, and you guys have to make a decision. A very small percentage of those ever actually get appealed, because that means going to court and all that. So the fact that a question has been raised doesn't necessarily mean that if you were to issue this comprehensive permit with whatever conditions you choose to put on it, that somebody's going to go and actually go to land court about an access issue. They might, could very well, but there's no guarantees. So, you know, from an efficiency standpoint, I don't want to go to court unless we have to go to court.
Thank you.
All right. You're all set, Mark?
I am.
Yeah. Charles?
I'll just add a little bit for now, that, you know, I agree with Mark. You know, I thought over the last several months that you were getting some sort of a judgment, and not getting another lawyer to agree with you. I mean, I think we can all agree that you could have 10 lawyers agree with you and 10 lawyers could agree with the other side. So, you know, for me, I'd really like to see a judgment on whether or not you have right to access the land, you know, from where you need to access it from before I made any decisions on the actual application. That's all I have for now.
Okay. I'm just going to go online to Joe. He's going to be the other voting member on this. Joe, do you have any comments, questions on this?
No comment, Tim.
Okay. Jeff, any comments?
No, I'm just waiting to hear more discussion.
Jeremy?
No, waiting for more discussion.
Okay. All right, from my point of view, I mean, the question, again, it comes up, does it come to the heart of the matter? I would think that it does. I think if the access to the site is in question, then it goes to the heart of the matter. So, with that being said, we would then, you know, if the board were to agree with that, we would then need to make a decision or ask or suggest that the applicant withdraw. Those are our options. Withdraw without prejudice, I guess I should say. So that's where I'm at with this for now. This is a public hearing. I'll open it up. I would just ask, I'm gonna take the people that are here first that would like to comment on this, but I would like to ask that the comments and questions for now be related to this access issue, as all other points for this application are off the table or put to the side for now. So is there anyone here that would like to speak on this matter?
Hello, my name is Diane Downs. I live at 12 Richardson Road. I'm part of the access to the Richardson Road extension. The language in my deed does not say anything about contiguous properties, nor does it say anything about the developer for Windview Heights 2 project. My husband and I opposed this project, and I would be willing to contest this in court.
Okay, thank you. Again, just to try to keep this organized, is there anyone here in person that would like to speak on this first, and then I will go back to people that are online? Okay, I'm not seeing anyone here. Is there anyone online that would like to speak? Just try to go one at a time. Sorry, I don't have everyone's names. I can see a hand, but
Looks like you're on mute, sir.
There's a Matt Gaines.
Hi, this is Donna Frank. I've expressed my concern in the past, but I'm concerned about ambulances, about the group home at the bottom of the hill, the heavy traffic that already takes place on this mountain, and the tightness of space. And I just couldn't even imagine trucks up here trying to access the other property without people not being able to get out of their homes. It would be very difficult on the people that own within the condo units. So this is just, I'm concerned about the safety and the access, the safe access. And, you know, that's my opinion as an owner and as a nurse. Thank you.
thank you. Is there anyone else that would like to comment? Mr. Gaines, I believe. I think you might be muted. We can't hear you.
We still can't hear you, Mr. Gaines.
Matt, can you dial in with a phone?
Okay, while you're doing that, I'm just gonna see if there's anyone else that would like to speak on this, and I'll make sure I come back to you. Is there anyone else that would like to speak on this matter that's online?
Yeah, I went for a moment. This is Ken House. I live in the Woodview Heights complex. And from my perspective, there are a couple of things here. There's the legal right to access, and then there's the practical ability to access. And when you look at the snow that we have out in front of our units right now, and it's not unusual to get the amount of snow that we just had recently. There is no way that you can get two-way traffic out in front of our unit. And the prior caller mentioned something about emergency vehicles as well. It just seems like a very dangerous and situation to set up and to force the residents of the current Windview Heights to have to endure to approve this project. Yeah, if this was foreseen down the road, the builder should have left more space between the units in order to allow this kind of traffic, and that was not done.
Okay, thank you.
I encourage any of the board members to come up and see what this area looks like, right now. And I don't know if the applicant is expecting the Windview Heights Association to pay to make sure that all the snow and everything is cleared out to allow access to and from his property. That does not seem like it would be a very fair and reasonable thing to ask an abutter to do. That's all.
Okay, thank you. I'll go back to Mr. Gaines, if he's got his audio.
Can you hear me now?
Yes, we can.
Excellent, thank you. Sorry about that. I don't know what's wrong with my computer. My name is Attorney Matt Gaines. I'm an attorney with the law firm of Marcus Rico, Emmer and Brooks, and I represent the Windview Heights condominium. I have spoken at some of the prior meetings on this issue. I guess sticking just to the access issue here about Richardson Road, I disagree with the applicant's attorney, not surprisingly, that this is a great issue. Town council was very clear in their opinion back in the spring, in May, I think it was, that there is no access. It is not really a legal gray area at all, in my opinion. But as to the heart of the matter issue, your town council tonight, Brian Winter, could not have said it better, frankly. It's a simple one. Of course, access over Richardson Road goes to the heart of the matter, because without access, it's impossible to get to the property. If you decided that it was not the heart of the matter, you would obviously be creating a very dangerous precedent here in the town of Burlington. I'm sure your town council would agree with that. If you decided in this case that access isn't important, you're opening the door to all future development in the town to not really have to prove access as a part of the project. And again, that is a dangerous precedent you would be setting. So I suggest that, you'll probably rely on the comments that town council mentioned earlier. I also briefly want to talk about the second application tonight, which not much has been talked about. That is an access issue as well, specifically whether or not the applicant has access over the condominium property. So, somehow by some miracle, if the applicant can win a court case that gives them access over Richardson Road, that's just their first hurdle. That gets them up to the condo property line. They then have to drive over the condo property line to get to the project. And that's kind of the subject matter of the second application that was filed, I believe, over the summer. And they're not going to be able to satisfy that either. Just quickly on that topic, the 2003 easement on which they rely from the condominium developer to the landowners, the Hussies and Buteros, states that the abutters easement rights over the condominium are conditioned upon the grantee, meaning Hussey and Butero, obtaining approval from the ZBA to amend the site plan and any applicable conditions or restrictions granted in the comprehensive permit. And the reference there to the site plan and the comprehensive permit is to the existing Windview Heights site plan and existing Windview Heights permit issued back in 2003 or whenever it was. I took a look at the application, the second application that was filed. I don't see what's being amended. how the site plan or how the permit is being amended. I don't have to tell you this, because I'm sure you've seen plenty of, applicants come before you with amendments, but, typically an amendment would be, okay, the original permit said you can build, 30 units, and now we want to come back and add 10 more. So we're going to amend the site plan to add, to make it 40 units. Or maybe, they're amending the site plan to change some condition about, buffers or trees or whatever it is. Again, probably better than I do. If you look at the application, nothing which resembles an amendment is before you. They're asking, ironically, given where we are in this whole access thing and what the applicant's attorney said a few minutes ago, they're asking you to amend the site plan to declare that the easement is valid. Exactly what the applicant's attorney said a little while ago, you don't have the power to do. So, and as noted in town council's memo, you don't have that authority necessarily to declare that an easement is valid. The ZBA cannot determine property interests by way of amending a comprehensive permit. So if you were to approve that application, I'm not even sure how you draft a decision on that second application in such a manner that it's an amendment to a permit without granting property rights, which you don't have the authority to do. So I just want to touch on that because I don't think much has been talked about that access issue. So again, if somehow the applicant can get over the Richardson Road hurdle, they have another hurdle, which I think is insurmountable as well. So that is all for now. I appreciate the time. Thank you.
Okay, thank you. Is there anyone else online that would like to speak on this matter? Okay, I'm going to bring it back to the board. I think we need to see what direction people are thinking on leaning in here, so we can give the applicant some kind of direction.
Well, my opinion is I think we should go with town council. Ask him to withdraw.
Mark?
Yeah, I just was interested in what this attorney for the condo said about the second, this whole issue of amendment, what your reaction is to that.
In my opinion, that part of the equation is a lot more straightforward from our standpoint. There's clearly an easement that was recorded. It's referenced in every single unit deed that went out of that condominium, so each of the unit owners bought being aware of that easement. That easement was a conditional easement under the terms that, as it was granted back in 2000, 2001, 2002, whenever it was. And in retrospect, and in my opinion, it wasn't very clearly spelled out exactly what the board, that easement, the condition was that Mr. Hussey had to come back to this board to get a review of what the plans were to do up there, because as I understand what the chair at the time said, they just wanted to make sure that nothing very egregious was going in there, so we wanted to retain some rights to stay involved. They obviously had no idea whether it was going to be a comprehensive permit that would come before this board or not, so that was their way of trying to keep tabs on it. The language wasn't very clear, clearly, and it doesn't say exactly what they wanted to have established in order for them to agree to it. So the application that we filed, frankly, just mirrored the language in the board and in the easement document that the chairman of the board at the time required be put in there.
Okay.
So I kind of agree with Attorney Gaines. I'm not sure exactly what type of relief would be necessary to meet the condition that this board put on that comprehensive permit, put into that easement 20 years ago. And in my view, that would be whatever the board wants us to do, we would do it. Do they want us to amend the original comprehensive permit plan from 2002?
Well, this gentleman says we don't have the authority to be making that decision, the way I heard it, maybe.
Nobody in this board was here back in 2000 when that decision was made, but this is the Board of Appeals, and you're the current people that sit in those seats. If they,
But it's an issue related to title and ownership and easements, and going back to the
again,
expertise.
so if it's going to wind up in the court, that's where it should wind up. That's why, that kind of gets back to what I'm talking about. We could go on, Attorney Gaines and I could go on and on about that, and we could also disagree on the first part, and
Gotcha.
and
I hear
we'll
you.
go around in circles.
I understand. And my sense is that, you know, I go back to my commentary earlier, and I think that it should be withdrawn, honestly. That's my feeling. Instead of us spending a lot of time on some very complicated issues, when y'all have a legal issue that needs to be resolved, that's all. Thank you.
All right, Charles?
Yeah, I mean, my position hasn't changed. I agree with the rest of the board right now. I mean, withdrawal seems like the most, what makes the most sense if we don't have a judgment on who can access the property. That being said, what would our other options be, you know? To hear the case and.
If the applicant were to not withdraw, we could take a vote now whether we would deny or proceed. And then if we decide to proceed, we would listen to the rest of the application and make a decision based on all of that information. But we would have to make it if it was not withdrawn, we would have to vote to make the determination whether it goes to the heart of the matter and whether we're gonna make that decision or not, so.
So that's the next.
That would be the next step, if it were not to be withdrawn.
Okay.
Joe, online, comments, thoughts?
Comments, no comments, thank you.
Jeff, do you have anything?
No, I don't have anything.
Jeremy?
No.
Okay. I agree with the rest of the board members. I think withdrawal is the best option here. I think it's a question that's up in the air that we can't answer, and I don't see how we could move forward with it without having that question answered. So I guess, we'll ask you what your thoughts are based on those comments from the board.
Based on the comments from the board, Mr. Chair, and I don't disagree with what you say. I mean, I certainly understand the issues. We would certainly prefer to, with the board's permission, withdraw this without prejudice, and continue to address the access issue and then come back to the board, rather than have this board take a negative vote that would force us to have to appeal it, because that sets things off in the wrong direction. So what I would request the board's consent is to withdraw our current submission without prejudice. And the hope from our side is that we will come back and refile once we have, you've been very patient with us, and we just don't want to strain your patience any further while we try to work this out. I would throw out, and I don't know, you necessarily have to decide this now, but the board might not be aware, the filing fee for a comprehensive permit is $5,000. And that's obviously to help defray some of the costs from the town side of the different boards reviewing things. So we paid a $5,000 application fee here. It didn't really get into the meat of the issue. We didn't get the engineering involved. We didn't get all of the technical aspects into it. So I would ask the board to consider when and if we do come back to refile, that the board would waive the application fee.
I think that would be appropriate, with just the one caveat that as long as it's not significantly changed plan, the
Understood.
whole process needs to be reviewed again from scratch because it's a totally different application.
Understood.
I think that's fair.
Understood.
Okay, then take a motion to close the public hearing.
Make a motion to close the public hearing?
Second.
Motion is made and seconded. We'll do a roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Joe?
Aye.
And I vote aye, 5-0. Okay, a motion to withdraw without prejudice.
I like the motion, but do I need to make two separate motions, likely?
Yeah, I would do that to be safe.
Yeah. All right, I'll make a motion to withdraw without prejudice 35 Mountain Road.
Second.
Motion is made and seconded. Roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Joe? Joe, you still with us?
Aye.
I vote aye, 5-0.
At the delay.
All right, I'll make a motion to withdraw without prejudice Richardson Road.
Second.
Second.
Motion is made and seconded. Roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Joe?
Aye.
I vote aye, 5-0. All right, thank you.
Thank you, Mr.
Okay,
Chairman.
thank you all.
I thank the board for your patience on this one. Thank you.
Okay, I know, Joe, I know you weren't feeling well. Are you gonna hang in there, or are you gonna jump off?
I don't have the agenda, no.
Yeah, sorry, I didn't jump off.
Yeah, all right, thank you. Forgive me for the agenda.
Yeah, thanks.
It's Wegmans. Okay, the next item on our agenda is it's a continued hearing for Wegmans as advertised for signage. Is the applicant here? Would you please come up to the microphone, introduce yourself, and give us an overview of the proposal?
Good evening, members of the board. My name is Michael Dolan from the law firm of Brown Rudnick here on behalf of the applicant, Volta Charging. Volta is a company that was founded in 2010 out of a passion for advancing electric transportation. And since then, Volta has mastered the art and science of developing cutting-edge electric vehicle charging networks. They're thoughtfully located along the paths of daily life. Volta's chargers are some of the most heavily used in the country, with thousands of units across the country. The Volta charging experience is a unique one compared to others you may have seen. Unlike other electric vehicle charging station companies, Volta does not charge fees or costs for the charge. And they do this to encourage electric vehicle usage. However, as the electricity that's provided for free to the consumer must be paid for by someone, Volta sells advertising space to brand name advertisers on their charging station-related media screens to generate the revenue needed to pay for the electricity. Volta's charging stations are seen as destination charging because the way they work is we try to put them in at locations such as malls, grocery stores, big retail stores, where folks could come in, shop for a while, and top off their charging needs. Here at the parking garage facility at Wegmans, on the lower deck of the garage, Volta is proposing a level 2 pedestal dual connector electric vehicle charger within the interior of the garage. There's a photo of one of those facilities, an example of one of those included with our plans. And on the upper deck of the garage, Volta is proposing 2 level 2 pedestal single connector EV charging units, together with 2 level 2 media stations that provide connectivity of critical charging data technology. Each of these media stations that I referenced that we're proposing up on the roof include a 2-sided digital advertising display screen, which is designed to target pedestrians and not drivers. The display screens are backlit, and they're similar to a TV screen, and they measure 55 inches diagonally. The ads on the screens are stationary, and they change approximately every 8 seconds. There's no video on the screens, and there's no sound or noise emitted from the media stations. We do have some sample photos here that I'd like to pass along. And what's that?
They're in packets for you.
Yeah, and packet for everyone. As you can see in those sample photos, the charging stations have nice crisp lines. They're sleek, attractive, and of the finest quality. Volta chargers are highly sought after and admired both by one more?
I get,
Okay. They're highly sought after not only by the EV charging customers and EV owners, but by commercial property owners and businesses alike who find their attractive appearance and free electricity a nice addition to the property. A representative of Wegmans is here with me tonight, and they are very excited to bring these stations to their shoppers. With respect to our application, the subject property is located in the PDD2 Northwest Park Planned Development District, and because of the digital ad display screens, Volta is seeking a special sign permit pursuant to the Northwest Park PDD zoning provisions. The building inspector had identified several portions of the bylaw that they thought could potentially be violative, so we came here tonight with this application. So specifically, what the building inspector alluded to was section 3.2 of the general bylaws, which are included by reference as part of the Northwest Park Plan Development Regulations. In this case, given that Volta's cutting-edge EV charging station model and the design of its units with display ads are a new concept, the electronic nature of Volta's proposed ad display screens may conflict with portions of section 3.2.4.2 and 3.2.4.6 of the general bylaw, which relates to signage. In this event, pursuant to the Northwest Park regs, an application can be submitted to the Board of Appeals for a special sign permit, which is what we have done. And as you know, a special sign permit can be granted in cases in which it appears to the board that the proposed type of signage was not contemplated by the Northwest Park PDD zoning provisions, and where enforcement of the PDD provisions would involve practical difficulties or unnecessary hardship, and if the relief may be granted without substantially derogating from the intent and purposes of the zoning provisions. In this case, the media station ad display screens have been situated so there is no visual impact on the surrounding areas. The proposed charging units and ad display screens on the top parking deck, which we're proposing, will not be visible at all from the ground. They're set back from the edges of the deck. There's a parapet wall around the perimeter, and as I say, those will not be seen from the ground. The proposed charging units on the lower level will also not be visible, as the lower deck is sheltered by the upper deck, the side walls of the garage, trees and landscaping, and its recessed shadowing in the garage area there. As I mentioned, the lower level chargers are inside of the parking garage. In short, the charging stations, we believe, will not have an adverse impact upon the surrounding commercial area. And for the reasons set forth in our application and here tonight, we respectfully request the issuance of a special sign permit.
All right, thank you. Jeremy, we'll start with you. Any questions or comments?
No, I don't have any questions or comments. Seems pretty straightforward to me.
Jeff?
So my question is, when does this become not a TV outside? Really is what I'm looking at. What are we opening ourselves up to as far as that goes?
Yeah, so this is just a static display. There's no video, so it won't be like a TV, and a TV has sound. There's no sound here. So it's akin to, in many respects, a display screen in some respects that you'd see when you're ordering food or something like that. So it does not open up Pandora's box in that regard.
Okay. I'd just like to make one request, if we do grant it, to have something in, verbiage in there saying no sounds are to be played.
Absolutely.
Thank you, that's all.
Charles?
I had the same question. Other than that, I think I would explain them, done with it for now. Any questions?
Mark?
Do you have any photos of where they're gonna be located? Like, you said the upper deck, and so I was just trying to get a sense for where
This is the lower level.
it's a lower level, and it looks like it's, is it gonna be in the back, or where are they gonna be located exactly? You're describing inside the garage, right? So,
if I walk over?
yeah, absolutely, come on over and show us what you're talking about.
So this is the blow-up area of where we're gonna go on the lower level, and so, when you first, have you been to this
Yeah,
Wegmans?
plenty of time.
Yeah, when you drive in there, it would be
There
in
all
the
the time.
back. It would be in the back here, and if you
So
blow,
wait a minute, so is that where it is right there? Is
that's
that
where
it's at?
we're proposing them right there.
Two of them, right
Correct.
there, and two over here? Is
Nope,
that-
those are just where there's the carts, people put the
Oh, put the
carts in.
carts in. All right,
So
there's
that's
two
just-
downstairs.
Excuse me, this is the
That's
downstairs,
downstairs.
correct. And then, so this next page is a blow-up of that, which shows those two spaces. And then we have the upper level, and these would be located, there'd be one media station with the screen here, and one here, and then the dual charger.
When you say media stations, how are they different? What's a media station?
It looks just like that.
Okay, so this is just pure advertising, is that what you're saying?
Well, this device typically has a cord in it in which the charger is located. With this, we don't have the space where we need it up in the top parking area, so they do need each other. A charging unit and that media station is more than just media, so there's connectivity between the two. There's an Ethernet cable that connects them. It shares technology, so in this case, so that we could make it work better, we put the chargers out and the media station aside.
But the media station has advertising and it has this connectivity.
Correct. Correct.
I mean, I agree with my brother over here in the sense that he's talking about it's not gonna be a TV, it's just gonna be. Now, answer this question, because isn't there something on the lower level right now that involves some advertising? Because I seem to recall having gone through that parking area.
There is. There are 2 units there right now. In 2019, Volta went to the building department, got an electric permit.
So those who went in without any objection, is what you're saying?
Correct. And
That's why you're wondering why you're holding us up?
no, I'm not saying anyone's holding us up. We're just doing whatever the town tells us to
No, I
do.
understand that.
What's the
but-
difference between those
Yeah.
and these?
Yeah, why did the building inspector allow those and not?
I don't know what happened in 2019. I mean, maybe someone back then thought they were
Is that
interior.
when were the premises built? When were they, oh, they go back a ways.
Way back, I think, a lot longer than that.
Yeah, okay.
Different
Yeah.
building inspector.
So that's all I have. I just was wondering, there's something there already?
No, we're not trying
You're not
to
trying to-
introduce something new. No, we're just trying to work with the town and be a good corporate
Yeah,
neighbor.
So you've already gotten some approval already. so. You didn't tell us that, brother.
All right, John, comments?
Well, I like it. I mean, I think certainly you gotta do something towards the electric cars when the whole world's going that way anyway. But as far as the changing the signs, how often do the signs change?
Roughly every 8 seconds.
Every 8 seconds? And there's signs on both sides?
Correct.
Are there lumens that we talk about for any maximum on there that we know of?
As far as the light?
Yeah.
Yeah, it's typical, a lot of people like to say, or, it's akin to if you drove up to Starbucks where you order on the screen there, it's about like that.
So, and does it run, it runs continuous, 24/7?
We turn it down at night.
What time?
I suspect between 12 and 6, the Northwest Park regulations talk about cross-reference to the general bylaw, and they say 12 to 6, no signs, illuminated signs, so we'll dim them down during that time frame.
12 to 6 being noon to 6 PM?
No, I'm sorry, midnight to 6 a.m.
Midnight to 6 AM? Because Wegmans isn't even open then, is it?
Exactly.
They're open till 11, though, from 6 to 11, so. 6 a.m.
I don't know if that's a huge thing, but, I mean, I don't really have a problem with them,
Yeah.
you know?
Nobody's gonna be there anyways.
Should we set a lumens amount onto it?
We usually do, so.
Yeah, I mean, we do, and we have a normal that we follow.
We usually put a restriction
I
of
would-
90 lumens per square foot.
Okay.
But it doesn't sound like you're even gonna be close to that, though.
All right, John, are you all set?
Yeah, I am all set, I think that would be nice.
Again, I agree with a lot of comments from the board, but I do have some concerns that quote unquote, it's gonna open up Pandora's box, so I have some questions. A lot of the same questions that we've already said. Is the 8 seconds time, is that adjustable? Can that be changed, or is that set in stone?
It can be adjusted marginally. As you can well imagine, the advertisers want exposure. They don't want to miss someone walking in and out, so the 8 seconds was determined to be the optimal space of time. And, you know, it's, a lot of our contracts tie into that type of.
So my next question with that is there like a limit on the amount of advertisers that you have at any given time? 5, 10, 100, and it just cycles through all of them and then repeats, or?
Maybe, I've got Michael Hirschberg from Volta here. Mike, do you want to answer that one?
Absolutely. So Michael Hirschberg, Engineering Project Manager for Volta. So typically we do different campaign ads just based on the campaigns that are kind of rolling at the time that we're working with. Everything's in good taste and good quality. Haagen-Dazs, FedEx, more or less just, and also as well as local advertisements. We've done Sabatino's Insurance. They're based in Everett. So we really kind of just roll through just whatever campaigns that we can get at the time that kind of continue to give us revenue, which we can then put towards.
But to his question, if
Sorry.
you had to, you know, a number, is this 100 different
No,
advertisers?
sorry, I apologize. So it'd probably be around 8 ads at a time that we'd circle through.
So you'd see 1 for 8 seconds, 2 for 8 seconds, all the way to 8, and then it would go back to 1 again?
Correct, yes, sir.
Okay. My preference would be, which I don't know, I'd be a stickler for it, is to see it be a little bit longer than 8 seconds, just so there's not like a, 8 seconds doesn't seem like a lot of time to me to be like a static image, like after 8 seconds and then it moving and then it's moving again, it's almost not static at that point. But you brought up, you know, the type of advertisers, and that kind of throws me a little bit too, to not necessarily know what's going to be advertised on these. Are there any restrictions that you have that?
Yes, we avoid cannabis ads, political ads, alcohol, anything, you know, kind of the phrase of sex, drugs, rock and roll, anything that really encompasses that realm. But we can also, you know, observe conditions of the board. I mean, we obviously are in good taste. I mean, we're partnering with Wegmans. They're a reputable grocery chain, so we certainly want to put up things that are respectful and not something that's controversial or in bad taste.
I mean, that's pretty much exactly what I'm looking for. I just don't know how to put that into a decision to make sure that it's a quote unquote in good taste, you know, because what's
Right.
in good taste to one person might not be in good taste to somebody else. So,
Yeah, but if you want to expressly condition it on explicit sexual, drugs, political, you know, we're fine with all that, because
All political,
yeah, right,
that's a good idea.
okay. And the time restrictions, that question was asked, so, I'm all right with it, with those restrictions. I do just want to state that this can come to this board because this is in a PDD. In other areas of town, this would not be able to be in front of this board even for a special permit. Because the type of sign that it is generally in just the regular zoning and general bylaw just wouldn't be allowed in this board. So it's like the use of the sign wouldn't be allowed. We wouldn't be able to grant a permit for it. But the language in the PDD does allow us to make a modification based on whether something, was not foreseen, as you mentioned. So, but I just wanted to mention that for future reference.
Yes.
That it's,
If owners of other properties are listening?
yeah, or if, if someone reached out to you and they
Yes.
said, we have a property and we'd like to, have some of your charging stations here. There are other PDDs in town, so it's possible that their
Yep.
language also, but I just wanted to kind of put that out there to make sure that everyone understood, the
Sure.
reasons that we're moving forward with this. So that being said, this is a public hearing, so I would like to open this up to the public. We'll start with the people that are in the room here with us. If there's anyone that would like to speak, sure, come up to the microphone, introduce yourself, please.
Hey, thank you, Mr. Chairman, and thank you, board members. My name's Tyrese Bryant from Wegmans Real Estate and Site Development Group. I want to thank you for hearing Volta's application tonight. Obviously, Wegmans fully supports the application you're seeing before us. There are a few items that, just for the board, has some questions around specific uses to condition possibly. So Wegmans partnered with Volta in 2019. We explored electric vehicle companies from across the country, and we ended up with Volta because of two main reasons. We wanted to provide a use across all of our 109 stores that were free to customers if they were in Massachusetts or if they were in Virginia or Maryland. And we also wanted little to no investment by Wegmans. Volta allows that partnership where there's no investment from Wegmans and there's no charge for our customers. The other piece is Wegmans does have a master agreement with Volta Charging that does not allow some of the items that you mentioned. So Volta is technically a tenant in our sites. So you won't see political ads, you won't see cannabis, you won't see any of the other items that were mentioned by board members because those are already in a master agreement. Obviously, not excluding you from conditioning those, but just thought that that we do have a master agreement with Volta that those items are not allowed. Wegmans has worked diligently to provide an amenity for our customers that doesn't provide sound. We don't want to create noise or sounds in our sites for our customers. As you all know, we are very particular about how we want our sites, our food markets, and we have worked hard with Volta, and they have gotten to know the Wegmans way of things, which are high standards in all ways. And I will say that Volta is also a company of high standards. That's why we've decided to partner with them, and that's why we're here to support their application. As we work with them, this year we're deploying charging stations in over 30 locations across our 7 states that we're in. Well, our 8th state will be in as well. So we are committed to working with Volta across our footprint, and thank you all for hearing our application and for your continued support. We want to make sure that we're supporting the Burlington community. And as one of the board members mentioned, EV is the way of the future. And it took a lot of folks at Wegmans to get on board to say like, hey, we have to provide this amenity because we heard it from our customers from Massachusetts, from across the entire company that they wanted this use in our facilities. So thank you all, and thank you for hearing me tonight. Appreciate it.
Thank you.
Thanks, Michael.
Is there anyone else here in the room that would like to comment on this proposal? Okay, is there anyone online that would like to comment on this proposal?
I have no hands up over here.
Yeah, I'll just give it a minute just in case someone's microphone is muted. All right, hearing none, I think we can take a motion to close the public hearing.
Make a motion to close the public hearing?
Second.
Motion is made and seconded. We'll continue with the roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Jeff?
Aye.
And I vote aye. All right, 5-0 to close the public hearing. Any other comments or questions from the board before a motion?
I have a question about, would it be in our purview to ask that maybe half of the advertisement be Burlington-based businesses to help support the community? Is that out of line?
I mean, it's, I guess, just the only, I mean, we've certainly partnered with a number of, you know, local advertisers that we worked with. I think it's a little bit, becomes a little tricky at that point for us to then sell our space to some of the larger names that are, you know, able to support us with a lot more revenue. So, I mean, certainly we can, you know, work with that, and I think we would make a good faith effort to, you know, install with local Burlington businesses. I mean, we certainly do a lot of outreach. I'm local here to the area, so certainly I would be happy to work with anybody that's willing to advertise. I think half is a large number, but certainly we would, you know, be willing to consider, you know, a certain percentage.
Well, maybe even having public announcements on there too, different things around town. Do you do?
So we've done something similar. For example, so Volta's California-based. In Huntington Beach, they did a promotion at the beginning stages of COVID, and they had like a scrolling line related to COVID. You know, wear masks, you know, use hand sanitizer, kind of at the very beginning of things. So certainly we could do something similar when town events come up, you know, 4th of July parade, Little League practice, whatever it may be. That's something also we can work into our stations.
That would be great.
Yep.
Yeah, and I guess, I mean, we've talked about the lumens, the hours, the content, and I know you said there was no sound, but should we get something in there about sound in case there's future iterations with speakers, just to
Yeah, we should
set
put it
that
in
straight?
there just to be safe.
As well as the hours between 12 and 6, you said you weren't gonna be running it. Are you gonna dim it down? Why even have it on at all and waste the power? Wegmans is closed, no one's coming through there. Why not have it just turn off between those hours?
We can certainly do that. Not a problem at all.
Okay, do we have a motion?
I'll make a motion to approve a special sign permit for Volta charging in care of Wegmans Food Market to approve, as shown on plan submitted with the application dated 5/21/21. Project number 50, or job number 501-24693. With the condition that there are no, the lumens do not exceed 90 lumens per square foot. There is no sound on the, used on the signs. There are no ads that are political or explicit in nature.
Video?
And-
Video?
Do we want to do video?
Yeah, probably should, just to be safe.
Yep. And there's no video on the signs. And that the signs are turned off at 12 midnight and turned back on at 6 a.m. That's it.
Okay. Do we have a
Second.
second? Motion is made and seconded. Roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Jeff?
Aye.
And I vote aye, 5-0.
Petitions.
Thank you all very much for your
Thank you.
consideration.
Thank you.
Okay, the next item on our agenda is a new hearing for 28 Harriet Ave. Could someone read that into the record for us, please?
Yes, sir. I shall read that into the record. 28 Harriet Ave, the petition of Claude and Jean Ballet for property located at 28 Harriet Ave, Burlington, as shown on the Burlington Census Records map and parcel reference 43-182-0. The applicant is seeking a variance to construct a 16-foot by 24-foot detached garage. The proposed plot plan submitted shows the garage would not meet the required sideline setback. And the violation is of Article 5, Section 5.2.0, which requires a minimum of 15 feet of setback.
Good evening, Mr. Chairman. Thomas Murphy here for the applicants, Mr. and Mrs. Valley, who are here with me at the table. They reside at 28 Harriet Ave, Burlington. As was read in the public notice, they are seeking to construct a structure on their, towards the back of their lot, to be used as a garage, 16 feet wide by 24 feet in length. And the proposal is that it be placed 5 feet from the left property line. This property, as you can see by the plot plan, is one of the older lots in town, down the Windmere section. It's 8,500 square feet. Obviously, it's a grandfathered lot. It was created years ago, back when that area was settled, but prior to the zoning bylaws. The zoning bylaws do require a 15-foot side yard setback, and we're seeking to do it 5 feet, so we're essentially looking for 10-foot variance. As the board knows, under the statute, we have to address 3 criteria that the chapter, the variance law applies to these types of situations. First one is a hardship. The hardship has to be related to the topography of the structures on the lot or the lot itself, which suggests in this particular situation, we have clearly a subsized lot. The legal lot in Burlington is 20,000 square feet. This is less than half of that, 8,500 square feet. So there's just not a lot of room on the property. The house is where the house is. It's been there for quite a while. It's kind of centered towards the middle of the lot, so there's really no other place where this garage could go on the lot without being in violation somehow or another with one of the setback requirements, whether it's side yard, rear yard, or front yard. So I would suggest that literal enforcement of the bylaw would prevent them from being able to build their garage. Mr. and Mrs. Valley are retired. It's obviously not a large garage, but allows them to put one car in there, and particularly in the winter, that is certainly a benefit to them. I would suggest to the board that allowing this is not a substantial detriment to the public good. Clearly, we're just speaking about one relatively small garage in a residential neighborhood. So there's certainly nothing that's going to derogate from the public good, nor does it derogate from the intent of the bylaw, I would suggest. Side yard bylaw, in my opinion, is to assure a certain amount of space between structures, namely a minimum of 30 feet, 15 feet on each side of a boundary line. We measured from the boundary line to the structure on the lot to the left of the Valley lot is over 40 feet away. So even though this is going to be within 5 feet of the boundary line, it's still 45 feet away from the nearest structure. So it clearly in excess of what the bylaws kind of mandate. There's also an existing fence that goes right along the boundary line that also adds additional screening and privacy. So again, I would suggest that this is not detrimental to the intent of the bylaw. I have with me that I'd like to submit some letters in support from some neighbors. Ms. William and Joanne McDonald of 24 and 26 Harriet Ave. Dan and Rosalind Harrington from 23 Harriet Ave. Brett Souza from 27 Harriet Ave. Rod Urquhart from 28 Wildmere Avenue. And Bill and Barbara Conway from 30 Wildmere Avenue. These are immediate abutters to the left and behind, and immediately across the street from Mr. and Mrs. Valley's home. I have 2 copies there for the board's review. All of those letters are in favor, requesting that the board support the request. So that is the gist of our presentation, Mr. Chairman. Obviously, we'll answer any questions or address any concerns of the board, but the Valleys are hoping that the board will look favorably in allowing them to build a very modestly sized garage to help them, particularly in the winter months.
All right, thank you. John, start with you.
Well, my first question is, why can't we move it 10 feet off to the right?
If you,
I mean, these aren't really the scale. I was there today.
yeah, This is a substance, I don't know if you guys got a
Yeah,
copy
that's
of
the
that
one
one.
I have. No, this is not the one I have.
That was submitted subsequent to our application, but I assumed it would be. But as you can see from that plan, John, if you were to go 10 feet to the right, a good, almost half of the garage is going to be behind the house, and kind of onto the patio, and trying to get a car in and out of there would be very difficult. There's just not a lot of room. Clearly, it's,
Am I reading this correctly? Is that saying it's 5 feet from the edge of the house on this side too, the front corner of the garage? The right front corner of the garage is 5 feet away from the back of the house? Am I reading this right?
oh, you're talking on that side there?
Yeah, right here.
That's what we're proposing.
Yeah, that's what they're proposing. So if you slide that over, like I said, it's gonna, A, go into the patio, and B, block the ability of a car. You'd have to do some sort of an S-turn, sharp S-turn to try to get into the garage. I have additions of these, Mr. Chairman. I don't know if everybody, this is the,
Yeah, I got one. Yeah, if you have a couple or a copy that we can pass around.
Yeah, no, I mean.
oh, I'm sorry,
if-
Jeff. Nice catch.
I'll wait, see what the neighbors have to say, whatever the board members have to say.
Mark?
No questions.
Charles?
I don't really have any questions at the moment.
Jeff?
This is gonna be parallel with the neighbor's shed, correct?
The neighbor on the other side of the fence
26.
there.
Yes,
It's gonna be, yes, in that general vicinity, yeah.
that's my only question right now.
Farther behind it, the way I see it, but
Huh?
farther behind it that I see it. Plus, there's a big tree there in the neighbor's yard too, so there's some of that will
Yeah.
provide some.
And one of those letters in support is from the neighbor who
Okay.
owns that property.
But the fence is chain link, isn't it?
No, it's final.
Oh, it's vinyl?
Jeff, you all set?
I'm good.
Jeremy?
All set.
Could I just
Yeah, go
say
ahead.
one more thing up to my head? So it's a single-car garage, and on the height, it'd be storage up top, or?
Yeah, it's a Reed's Ferry shed, so there's no second floor. There would
No
just be
second
some
floor.
cross beams that you can maybe lay
Okay.
2x4s on,
That's what I'm looking for.
plywood.
All right, thank you, Mr. Chairman.
Okay, that actually probably answers part of my question. So this is like a prefab type of structure?
Yeah.
So what my question was going to be is why not build a garage that's attached to the house?
Money. I mean, we talk to people, and to start to open up the house there and everything, you start to get up towards $100,000. And Reed's Ferry can come in and put it there for 20, 25 grand. That's more in my ballpark.
Yeah, okay, I mean, that makes more sense. It only moves it over 3.3 feet, so it's not a major difference. It just, I had to ask the question.
Yeah.
I think you prefer that, it was attached, but I understand the complications of trying to do something such as that.
We had grand hopes, and we talked to some people, and we were kind of blown away by the numbers, and
And the
then
price is only going up.
adjusted.
All right, I will open this up to the public. Is there anyone here that would like to speak on this matter? If you could please come up to the microphone, introduce yourself.
Is this one?
Sure.
Yeah. Do you want to sit down?
You're good, Carl. This is actually the microphone.
My name's Carl Christensen. I'm right next to his property, and it affects mine. And the thing I want, he's got quality everything in his yard. He's gonna bring the value of my house up, and it's a win-win for everybody. So that's my thoughts.
Okay, thank you.
You're welcome.
Okay, is there anyone else who is here that'd like to speak? Please introduce yourself.
Hi, my name's Dan Harrington. I live at 23 Harriet, directly across the street from the Valleys. I've been there 25 years. The house across the street has never looked better. They've done so many improvements on it. I can't see them putting anything there that wouldn't look as nice as the house looks right now, so as far as I'm concerned, I'm in favor of it. Hopefully it works out.
Thank you.
That's all I have to say.
Is there anyone online that would like to speak on this matter? All right, let's just leave it open in case there's more discussion, but we can close it after. Before we get back in, so you're saying that this is just a single-story garage, right?
Correct. Their standard wall heights, I believe, are 6 feet, or maybe 6'6", and we would just add an additional foot to the wall so that you get a little more overhead storage. I drive a pickup truck too, so it has to be just a little taller to get the truck under, but
Yeah,
it's an A-frame, it's not the gambrel or...
Yeah, I think since we don't have like a picture of the structure, I think I'd be a little more comfortable just saying that it needs to be single-story, you know. It's kind of a loose term, but, you know, it means that you can't go back and build another floor on top of it later either, so.
Right.
That's.
We just downsized.
All right, any other comments or questions from the board?
I don't have any comments. Looks good.
All right.
What kind of foundation is it gonna be on?
Cement pad,
Just a regular pad, no footings?
No.
correct.
Did your wife know the garage was for your truck and not her car? Before tonight?
We were gonna talk when we leave.
I got nudged under the table. You didn't see it from that angle, but...
Wait till after the vote before we have that discussion.
Yeah, really.
Do it.
All right, we'll take a motion to close the public hearing then.
Make a motion to close the public hearing?
Second.
Motion is made and seconded. Roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Jeremy?
Aye.
And I vote aye, 5-0 to close the hearing.
Thank you.
Yes, thank you very much.
Not done yet.
Oh,
Oh, that was close. Oh, I'm so sorry.
Put the horse before the car.
First they close the hearing, then I'm over there.
that's why we're here.
I'll make a motion to approve 28 Harriet Ave for a 10-foot, variance, side, Jesus, 10-foot side variance for shed, I guess it's called, a detached garage.
Garage in the application. In the
Yeah,
advertisement.
advertisement. As shown on plot plan dated 1/20/22. With the condition that the structure is only 1 story.
Second.
Yeah, that's fine. The motion is made and seconded. Roll call. Charles?
Aye.
Mark?
Aye.
John?
Aye.
Jeremy?
Aye.
And I vote aye, 5-0. Now you're all set.
Now,
There we go.
thank you.
Thank you very much.
Okay. The next and last thing on our agenda is a review of the minutes from our January 18th meeting. People had
Make a motion to accept the minutes?
okay, might as well just, Joellen, can I just have 5 of them vote on it? I wasn't here, I don't need to abstain the 5 of them. All right, so roll call. Someone seconded it, right?
Second. Okay.
Charles?
Aye.
Mark?
Aye.
John?
Aye.
Jeff?
Aye.
And Jeremy?
Aye.
Okay. That's the minutes.
Make a motion to adjourn?
Second?
Motion is made and seconded to adjourn. All in favor?
Aye.
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 Opposed?